human rights. Whatever the cause, one is irresistibly driven to wonder about parliamentary sovereignty and sovereignty in general. These recent attempts of UK government to kind of threat European human rights system during the British presidency of the European Council, or to repeal the Human Rights Act, show how desperate the governing bodies are in a way. Not to mention forthcoming referendum on independence of Scotland due in 2014, or past failed referendum on the new voting system last fall. But this is nothing to compare to the ever new project of the British Bill of Rights, for which a second consultation paper was delivered last July by the Commission on the Bill of Rights. Final results are expected by the end of the year, so like in a few days. Rights are as recurring a theme as the House of Lords reform or the devolution system. However, these days, forms of rights protection are the most debated question. Here I shall address the relevance of the rights question to the constitutional settlement of the UK, and especially to the judge's role as far as the exercise of sovereign power is concerned. I will proceed in a very French manner through a twofold reasoning, showing at first that the question of rights reveals a question of political power, and secondly, that the way Britain is addressing the matter reveals its constitutional specificity. So first, the question of rights reveals the question of power, of political power. In this first part, I will try to show that rights debate is not at all a legal debate in the first place, but a truly political one. The current British Bill of Rights project is the perfect illustration of such an assertion. This project stems from a conservative Liberal Democrats political commitment dating back to 2010. The coalition program encompasses the compromise reached by the two governing parties. One of the directions is to replace the Human Rights Act in order to, quote, define the core values which give our identity as a free nation. As David Cameron, the current Prime Minister, said, the coalition program promised the establishment of, quote again, a commission to investigate the creation of a British Bill of Rights that incorporates and builds on all our obligations under the European Convention on Human Rights, ensures that these rights continue to be enshrined in British law and protects and extends British liberties. The purpose is then to promote a better understanding of the true scope of these obligations and liberties. I will then use Mark Elliott's comment to show the political dimension of arguments that are following these kind of declarations. The wording of the program is the fruit of a compromise with the more liberal branch of government. So the point is that it appears, the program appears smoother than what it is as far as the human rights are concerned. To realize the intent behind, it must be referred to the discourses of those in charge at strategic positions. For example, well, the Prime Minister himself and Attorney General Dominic Grieve. Both expressed the opinion of the Tory party, in fact. And these are positions, they are in positions to implement this kind of opinion now. Dominic Grieve expressed in the clearest terms the objective of a conservative promoted Bill of Rights. I quote, "The conservative approach is to replace the HRA with our own homegrown Bill of Rights in areas where ECHR rights are absolute, such as Article 3 prohibition of torture. Those protections will not be removed, but there is no reason why our courts should be bound by Strasbourg Court jurisprudence if their own interpretation is different, particularly when rights should be balanced by responsibilities. We should also look at restoring a better balance between Parliament and the courts. It is wrong that primary legislation can be altered by statutory instrument if found incompatible with the Human Rights Act, nor should our courts have power to stand a statute on its head. All these things can be addressed in our proposals for a Bill of Rights. So, a Bill of Rights would be used to help Britain, in a way, to leave or to put distance with the human rights, European Convention on Human Rights system, without being alienated from the circle of rights-respecting nations. A Bill of Rights Commission was created to steer the public debate on the subject. A member of this commission, now retired, was Michael Pinto-Dushinsky, a senior consultant in constitutional affairs in a think tank called Policy Exchange. He stood overtly for a possible withdrawal from the jurisdiction of the European Court of Human Rights, or even from the Convention itself. Knowing this, the British Bill of Rights project could be interpreted, as Mark Hewitt did, as a hostile move against the HRA. It appeared as such, in the opinion expressed by some raging against the judge's use of the Human Rights Act as a criticizing tool. This remark is inspired by the attitude of the Prime Minister towards a 2010 decision of the Law Lords overruling part of a statute on sexual offences. This was in our Secretary of State for the Parliament. Prime Minister claimed that the decision was offensive, I quote, and flew, I quote again, completely in the face of common sense. As a consequence, he announced that a Bill of Rights Commission would be established imminently because it's about time we started making sure decisions are made in this Parliament rather than in the courts. So the declaration is clear and clearly against the court's power. This is to prove that the Bill of Rights' current process expresses genuine defiance against the court's power. The favored political argument is about Parliament prevailing on the court's stand. Repeating the Human Rights Act process in the back in the mid-90s, the current UK Bill of Rights process is the result of a strong political will stemming from a changeover of political power between parties. So the Human Rights Act stands for, or standed for, a new Labour policy, namely the introduction of a rights-based education of public authorities in general and lawyers in particular. The new Labour and the majority of academics advocated a Human Rights Act by claiming that bringing rights home, that was the expression, bringing rights home was designed to acclimate Britain to a culture of rights, namely a culture of political legal justification, as David Furmans named it. Interestingly, the current promoters of a British Bill of Rights now send back a slightly different signal, but in no way contradictory to the first, to the New Labour signal. For them, bringing rights home now means to get rid of external influence, especially Strasbourg's, and to apply homegrown rights allegedly respecting parliamentary sovereignty and governmental rule. According to this position, homemade rights should be better integrated into national legal order and would be more respectful of the rule of law itself. This project can thus also be seen as extending the former, in that it acknowledges the incorporation of rights and recommends their fully local handling. However, the result of a first public consultation from the Commission on the Bill of Rights shows a discrepancy between the government's message and the way it is perceived. First interesting finding from the first consultation. The opponents of such a Bill of Rights are more numerous than advocates. This is an interesting finding in a way. And second interesting finding, the conflict does not focus on the sovereignty argument, but on the extent of rights protection. A UK Bill of Rights would be, kind of in HRA minus for the opponents, whereas it would add new rights for advocates. So this focuses on this point mostly, and not on sovereignty questions. So the entire Bill of Rights position is essentially grounded on the rejection of the political intent lying behind the Bill of Rights project. The new perspective of the Bill of Rights would amount to a rights repatriation process whereby progress obtained through the ancient, well, the ex-HRA or the HRA could be reversed, and the past attitude towards right dating back the Thatcher years could be restored. So this is the fear here. This view is stimulated by declarations concerning the possible repeal of the HRA, as I said, and current conflict with the European Court of Human Rights. This conflict burst at the high-level conference meeting at Brighton last April at the initiative of the UK chairmanship of the Committee of Ministers of the Council of Europe. It is exemplified by the clearly expressed wish from the Prime Minister to curtail powers of the European Court. He said, "We are hoping to get consensus on strengthening subsidiarity, the principle that, where possible, final decisions should be made nationally." On the reverse, the pro-Bill of Rights position stands on the argument that the HRA did not manage to inspire popular confidence and is viewed as a kind of Trojan horse, whereby foreign rights violate British Parliament's supremacy. This would explain the lack of popularity and understanding of some decisions founded on the HRA. Prisoners' voting rights case in Hurston, UK, this is a case from 2005, is usually raised as the shocking example of such an undue infiltration of ECHR's interpretation of convention rights. This is particularly so, and this is a particularly present current argument since the government published a draft bill on the voting eligibility of prisoners on last 22nd November. So for this camp, a UK Bill of Rights would trigger a positive appeal to the public and manage what the HRA allegedly failed to achieve, a rights consciousness rooted in British constitutional tradition and popular mental representations. This is the way it is put forward. It could even successfully entrench, here comes the point, it could even successfully entrench convention rights and newly added rights as part of a written constitution. It would thus achieve, at least partially, one of the Liberal Democrats' wish of a written constitution. Indeed, in a policy briefing, the Liberal Democrats were in favor of a fully written constitution for Britain. Here comes the supposed problem of the constitutional status of rights in general, which goes much further than the formal dilemma between a HRA or a Bill of Rights. This question was raised the same way 15 years ago, in fact, during the HRA debate. Whatever the medium of rights, the underlying difficulty is of legal nature. It is about the constitutional status of rights, namely the way in which they institutionally matter. Let me now turn to the second part. Second part, Britain's answer to the question of rights reveals Britain's particular mode of dealing with constitutionality. To handle the specificity of Britain's constitutional settlement, I will articulate two complementary points inspired by the way the second consultation paper delivered by the Commission on the Bill of Rights poses the problem in last July. First point, constitutionalism deals with entrenchment of rights. So the first question is entrenchment of rights. In its second consultation paper, the Commission on the Bill of Rights acknowledged what Tom Hickman's in his it was in the UK Constitutional Law blog. Tom Hickman's, a constitutionalist, said that the Commission neglected the how question in the first consultation. So he criticized the first consultation as lacking consideration for constitutional matter. The second consultation paper heard this and poses the how question through four sets of questions, turning from the incorporation of the convention to the legal article, turning from the incorporation of the convention to the legal articulation of the Bill of Rights to the Human Rights Act, and to the formulation of rights as distinct or identical to the HRA. It could be interesting to read the question, but I have no time to do it. So, echoing the policy briefing of the Lib Dem party, demanding a full written constitution, the Commission on the Bill of Rights is not reluctant to the option of a partially written text which would deal with constitutional settlement through the organization of rights protection. So this is how the relevance, the constitutional relevance of rights is worded. It seems to be the approach supported by those in favor of a new UK Bill of Rights. According to this approach, that used to be present already in the pre-HRA debate, rights entrenchment was presented as a first step to a formal and substantial change in the British settlement. It was supposed to open way to constraints imposed on the Parliament-government couple, and to a dramatic increase of power of the House of Lords, changed into a kind of constitutional court, namely a competent judge to overturn anti-rights legislation, as in exemplary constitutional states such as the US or Germany or South Africa. Part of the work has been done with the HRA and the Supreme Court reform, but one cannot conclude that an institutional revolution has occurred. This is my point. This argument is best illustrated by the court's reviewing power, and this is my second point here. A point that was worded in that way about the 1995 revision of the Icelandic Constitution. It is that judicial review is revitalized by rights and awakes the traditional question of power distribution, but does not, in England, in Britain at least, does not depart from the traditional handling of checks and balances. As a preliminary remark, now which is 4 minutes, it should be noted along with David Fenton that Bill of Rights versus HRA debate should not be addressed on the basis of the argument that the HRA is responsible for the domination of UK by the Strasbourg Court. The fact that the UK is bound by the court's judgment stems from its accepting the jurisdiction of the court and the individual complaints mechanism. The international acceptance of it. Okay, so it's an international obligation that forces UK to abide by this case law and this text, the convention. So therefore, the link between the UK and the ECHR is the result of international obligation under a treaty, and it is not due to interference of unelected foreign European judges, among other suspicious features that are usually used. Hence, the problem should not be examined from an international perspective, but from a national one. What is the influence of the newly entrenched rights on the structure of power in the UK then? First of all, the rights enshrined in the HRA are specifically designed to counter states' abuse. Therefore, rights stand as new standards of review of political action, either executive or parliamentary, as Paul Craig puts it in his foreword to Tom Hickman's public law after the HRA. He said, the HRA has been of major significance in the reconfiguration of public law. the very profile of judicial review has altered such that there are far more cases raising human rights-based claims in the context of judicial review than there were hitherto. So the constitutional relevance of the HRA concerning judicial review stems from the fact that the courts inherit an amplified responsibility. They benefit from an enlarged scope of review in that there are not only to scrutinize administrative action, which the common law extensively elaborated through concepts of reasonableness, Westminster case, and the following case as well. It's very well done by the common law already, and the other concept is proportionality, which goes in the same common law process of elaboration. But there are also to assess now the legislative intent of Parliament. So, and this is more tricky, problem. From analysis of the development of case law, it appears that whatever the type of review, the monitoring power of the judiciary was enhanced during, under the influence of the HRA. It was so concerning the standard of review, so the application of the HRA to the rationalization and the implementation of the concept of reasonableness. I don't enter into detail. For the same reason, the principle of proportionality as a standard of review is constantly reinterpreted in the light of the Strasbourg case law. According to the HRA, now the limit of the Convention rights concerns another very important decision maker, the Parliament itself. So British courts have some jurisdiction to interpret legislation in a manner which is consistent with the protection of Convention rights. But it is not absolutely convincing that it is possible to talk about a power of review here, since the Act protects the sovereignty of Parliament by preserving the validity of enacted primary and subordinate legislation when it is interpreted so as to be compatible with Convention right. This is section 3.2 BC of the HRA. It is all the more unexpected in case of incompatibility, since the declaration of incompatibility made by the court has no effect on the validity and enforcement of the convention. This is section 4 and more, and there are two cases more. The HRA excludes houses of parliament from the risk of acting unlawfully, even if contravening the convention rights. And in addition, a failure to introduce a proposal for legislation or to make any primary legislation or remedial order to incompatible legislation is not considered as entering the scope of the HRA. Finally, the government's taking part into the legislative procedure when supporting a bill or enacting subordinate legislation is not much committed to respecting convention rights. As a result, and bearing in mind that the common law and not the HRA is at the origin of the reviewing power of the judges, the extension of judicial review does not amount to strike a completely different balance between Parliament and the courts. Judges are not yet vested with a power to alter Parliament's decision. And this is the point I make here. It is that the human rights performs no revolution at all as far as the balance of powers is concerned. The judiciary, whether British or European, is not given an outstanding role. Parliamentary sovereignty is safe, as well as the margin of appreciation of the executive. It can only be said that, in my view, that the HRA prolongs and in a way quickens a usually slower process relying on cases whereby UK judges find themselves vested with power to protect individuals from state action. Doing so, they are also responsible for giving some kind of guidance to public authorities, but in no way orders. The most compelling obligation that both government and parliament are subject to are those they self-inflict, in fact. In that way, they are still, or they remain sovereign. So to conclude, I would say that, as others suggested, that the Human Rights Act acted as a common law plus and reactivated the dialogic nature of the British constitutional settlement, thus continuously performing the way Britain works as Dicey formulated decades ago. And as far as a future or would-be Bill of Rights for the UK is concerned, it is highly improbable that it play a different role from the HRA with respect to parliamentary sovereignty.
Many thanks, Charlotte. I apologize to postpone the debate. Felicitations, congratulations. We will if you want to leave some luggage or personal belongings in my office, it's possible. They will set the camera in the office. The lunch is just here. I hope the queue will be rather short, and we have time afterwards. If you want,
and we may start earlier.
yeah, we may start.
If the room is
So we will not be here in the afternoon.
No, in another classroom.